This is actually a dress. I went to the Met Gala in 2018 and I was going to wear this dress or another one. I was going to modify it and make it even more Met Gala-y. That's not a word, but it is now. And I couldn't decide between the two, and I ultimately chose this red one. And this one I had always wanted, and it was worn by another incredible actress, Can, a few years ago. But I loved it, so I was like, oh, okay, beautiful piece is beautiful. Should be worn many times. She wore it so beautifully, and so now here I am. That you're not defined by anything any man has ever done to you or will ever do to you, that your identity is you and you define that. And you may, even if you don't have the emotional fortitude to be able to see it at the moment or do what you need to do, that like, your identity is only defined by you and never a man or never anything that happens to you, and that there's joy and optimism and love in the world.
Hi besties, it's Katie from Without a Crystal Ball. Welcome back to my channel. Well, while we wait for Blake Lively's deposition, which is happening today, and the new second amended complaint by Wayfarer, over the weekend or last week, Blake and Wayfarer ended up in the court in California, and she is seeking to have a motion to compel compliance of a subpoena of certain third parties of Wayfarer and their employees, and one person that's not an employee, Justin's health coach, that prescribed probiotics, which apparently Blake felt was being used to weight shame her, even though she uses probiotics and some people use that to manage weight. The evidence that Justin showed in his complaint that's now dismissed, they were discussing helping her build up her immune system after having several rounds of strep throat. But regardless, she is in California. And oddly, after the judge, Lehman, denied her motion to compel for lack of jurisdiction and for not bringing it to the proper court, and he doesn't have he doesn't have the jurisdiction to rule over a subpoena that has been issued in California, Blake is seeking to have the subpoena transferred to the compliance of it, transferred to New York, which isn't going to happen. And then also she's demanding that they produce documents, which they've already agreed to produce. And I don't know how the judges in California are going to rule, but Lehman said that if they agree to produce, you can't force them to produce before the deadline. Substantial deadline for most documents of discovery is July 1st, and then all discovery is done on August 14th. So they still have several weeks before everything needs to be produced. So, but in her filing, they did a joint stipulation, and I thought it interesting because Miss Lively admitted in this document that she does not have the evidence to prove her claims. If you need to rely on third parties to prove your claims, you don't have a very solid case. Obviously, discovery is open, right, to get evidence, but generally speaking, you should have a decent amount of evidence when bringing forth claims to prove what you have. But it sounds like she doesn't have what she needs to prove her case. So in a joint stipulation, obviously Wayfarer is fighting back. Blake is asking the court to either transfer it back to Lyman, which he won't do. The court won't do. I don't know if it will be a female or a male judge, but the court is not going to transfer it back because Lyman already denied and said he didn't have jurisdiction over it. But she is also, listen to this, the Wayfarer parties do not contest that Ms. Lively validly served the subpoenas, which each list a place of compliance located within this court's jurisdiction. Each of the subpoenas seek information that is plainly relevant to the actions, including information about Ms. Lively and Mr. Reynolds, the actions, the film, and its marketing. Complaints and grievances raised by Ms. Lively in connection with the film, harassment, discrimination, workplace misconduct, or other inappropriate behavior related to the film. It is interesting that she is still seeking information about the marketing when her case, Justin's case, was dismissed, but she might have put this together before the case was dismissed. It's kind of confusing here, but she wants information about the public relations services provided by defendants Jed Wallace and Street Relations, which is odd because she could literally get that directly from Jed. She wants information about services provided by Melissa Nathan, which she could get directly from Melissa Nathan, phone records relating to allegations in the Lively complaint, and Wayfair third party's decision to hire the same counsel as Wayfair. That's not going to be something she can get. You can't get information about attorneys and who's hiring attorneys. That's all covered by attorney-client privilege. She's not going to be able to get that. But then she says, whether Miss Lively can obtain these documents and communications will affect her ability to prove that she experienced inappropriate and unwelcome misconduct while on the set of the film, that she raised concerns about such misconduct, and that the Wayfair parties coordinated the retaliation campaign against her for doing so. She says she needs part documents from them to prove that she experienced inappropriate and unwelcome misconduct. Why would she need evidence from them? That would be her evidence. We know that she used an attorney. We know that they sent letters. They threatened to sue. She would have all of the emails and communications. Why would she need them to prove that this happened on the set and that she raised the concerns and that they coordinated the campaign against her for doing so? So what that tells me is that she actually doesn't know if a retaliation campaign was ever lodged against her. Because, like I've said before, if you respond to someone because they have put out something about you and they're seeding negative information about you, that's not retaliation. Retaliation for SH and for bringing forth claims has to be very purposeful. In sexual harassment, and to prove sexual harassment, oftentimes retaliation is losing your job, losing opportunities, having yourself be isolated or marginalized from other people, your boss changing their attitude towards you because of what you've brought up, being fired. But retaliation is not discussing other issues that happened on the set. Okay. So if other things came up that were outside of these claims that she's bringing of sexual harassment, if they're asked about details about editing, or how did she get a cut, or how did she get the producer credit, or that kind of question, that's not retaliation, because theoretically speaking, creative differences would have nothing to do with sexual harassment. Sony versus Wayfair and who they choose the cut and who's going to get the cut, what does that have to do with sexual harassment? It should have nothing to do with sexual harassment. So if they are responding to those kinds of questions, and if they are responding to you making threats against them, or if they're responding to you putting a story out in Daily Mail or Page 6 that says that he's abusive and he became his character and he didn't take into consideration your point of view and made you feel like your point of view as a woman wasn't valid or seen, and that you had to rewrite the script because Colleen Hoover said so. And Colleen Hoover needed to be more involved because Colleen Hoover wanted to be, and Justin just didn't treat the women very nice on the set. If he has to respond to that, that's not retaliation. She says, among other topics, these documents and communications will specifically evidence the Wayfair's knowledge about the misconduct on the film set and how it and other Wayfair parties reacted to the reports, how and when the retaliation campaign was formulated, the web of individuals involved in the campaign, and how social media was manipulated in furtherance thereof. She has no proof of any of this. She should have proof of this. Didn't she get everything that came from Jen Abel's phone? I thought that was proof. I thought that was the proof she needed, that this actually happened. It says the Wayfair parties are executives, employees of Wayfair, and many of whom work directly with Baldoni, and text messages already obtained show that certain of them were directly involved in the retaliation campaign. They're likely to possess information that's not only relevant, but essential to her claims and defenses. Wayfair admitted as such by identifying Wayfair third parties in their initial disclosures. Well, not really. And Wayfair's initial disclosures would include them because they would be witnesses to what didn't happen and to what Lively did on the set. She even says there are no active disputes regarding whether the subpoenas are valid, whether it seeks relevant information, or whether the subpoenas are subject to their objections. All that's left is for them to comply and produce documents, which they still have until July 1st and August 14th to produce. But even with the extensions that she's provided, the deadlines for compliance have long since passed, and none of the parties has produced a single document. Now, Wayfair says that she gave them only 20 days to comply with these subpoenas and that everything that she is seeking is pretty broad. And they have been going through all of their repositories and personal devices and then determining what's privileged versus private and what she can have versus what she can't. And so they are still working on it. And they say that they have told her over and over and over again that they will comply with the subpoena. And it says the Wayfair third parties agreed to produce the responsive non-privileged documents in their possession, custody, and control despite the burden that the production carries. A substantial volume of data has been collected from the Wayfair servers, databases, and other repositories and is being reviewed and produced on a rolling basis, a process that has already begun. To date, Wayfair itself has made multiple productions, including production of emails and other professional materials for the subpoenaed custodians. Counsel expects to be complete with production by July 1st. Okay, so they'll be done in about a week. Rather than allow the third parties the time needed to fully comply, Lively has rushed to multiple courts, insinuating that these third parties are purposely moving slowly in some kind of coordinated effort with defendants in the main action. She's mistaken. Wayfair encourages production of the responsive documents as they will evidence the falsity of her allegations. However, the Wayfair third parties needed more than a few weeks to image and produce all of the documents responsive to the 177 requests. That's a lot of requests for documents. Regarding materials within the sole possession, custody, and control of the Wayfair third parties, all relevant personal devices of the subpoenaed individuals have been forensically collected where applicable. These substantial data sets are currently undergoing priority review, and the collected documents and are responsive and non-privileged will be produced in accordance with ESI stipulation in the Southern District of New York action. And that will be completed by June 27th, 2025, but in no event later than July 1st. So do you remember how last week she told Wayfair that she shouldn't have to produce documents faster than July 1st if they're not going to produce documents faster than July 1st? I mean, it's kind of the same argument. She just wants the records now versus having to wait. And she's doing this, I think, just to continue to harass these people. It's just another way for her to drive up the cost of the court and see if she can get more attorney's fees for damages. And it's just another way to intimidate people that these people that she's petitioning, these are not millionaires. These are not people that probably make, huge salaries. These are people that work for a small studio. Tara Hanks might make a decent amount of money, but some of these people probably don't. They probably don't have the resources or the financial resources to deal with these kinds of abusive filings. And Blake says that them producing documents will prove her claims or maybe not disprove her claims. And Wayfair is confident that what they hand over will prove that she made this whole thing up and that it didn't happen. So who do you trust with that? Do you trust Blake, who says, I know this happened and I have proof that this happened? Or do you trust Wayfair, who says, trust me, trust us. We have information here that proves the falsity of her claims against us. Now, when you file a lawsuit, discovery allows you to do a very, broad look at all the parties involved to prove claims. But again, if you bring a lawsuit against someone, you should be able to have evidence of your own to prove the claims that you have. In civil court, it's not beyond a reasonable doubt. In civil court, it's 51% to 49% that what happened to you happened. So you have a lower bar that you have to meet to prevail in a civil case. But the burden of prevailing and the burden of proof is on you, the plaintiff, if you're going to bring forth a claim against someone. Therefore, before you even consider bringing a lawsuit, you should have ample evidence to prove the claims that you are making. Filing a lawsuit based upon a theory, a hunch, or a concept might mean that you file a lawsuit and you realize that your hunch was wrong, and that you wasted a bunch of time, you wasted all kinds of money, and you bothered a bunch of people that were innocent of whatever it was that you were claiming. Discovery can be used to strengthen your case, right? But you should have enough on your own to prove your case. So you can get documents to try to strengthen your case. You can get experts to testify. You can get witnesses to share their side of the story. But when you're going to go to a court and file a lawsuit, you really should have evidence, enough evidence on your own to prove the claims. What you get through discovery should only further support your claims. That's been my experience, having dealt with numerous lawsuits filed against me that have had literally no basis of reality or fact. I did not do it. And similar lawsuits like what Blake is doing to these people were filed under a hunch, a thought, or just, I'm going to be icky and I'm going to just harass people because I don't like her, because she's not attached to a large publication. And if I sue her, then she'll shut up. Right. And so they file these like wild lawsuits that make all kinds of defamatory allegations against their target, only to have no proof of what those claims are. And then after going through the process of discovery, you find out, oh yeah, we were wrong about her. We didn't have those. Or the person suing you, like Blake, won't give up documents that prove her claims, or they actually show that they're disproven. The consequence of filing a lawsuit without sufficient evidence means that you have the risk of losing a lawsuit if you fail to meet the burden of proof, even if you are in the right. You've wasted time and expenses. Pursuing a lawsuit without adequate evidence can be costly and time-consuming. And then you have the potential liability for cost and fees. If the defendant can demonstrate that you filed the lawsuit in bad faith and without evidence, you might be ordered to pay their costs and expenses. You don't need to have all of your evidence, but you should really have a very strong foundation. And it sounds like Blake doesn't have that, because if she needs to rely on emails and documents from Wayfarer to prove that she experienced misconduct and that this retaliation campaign was set up because of what she experienced on the set, which we know it's not true. We know that's not what happened here. She didn't have the evidence, so she just filed this for reputational purposes. Again, admitting that she did this in bad faith. But again, what do I know? So again, she is continuing to harass people that have limited resources and demanding they turn over very private and personal information to her. And this is why I think people just don't speak out against them, because they're scared. And honestly, she wants proof that from all of them that they somehow spoke to Chastity Flaw. Seriously, she is still after trying to prove this theory that Chastity has said over and over and over again. She's trying to say that Chastity was told or instructed by someone at Wayfarer to release her interview from 2016 that showed her being rude to Chastity and ignoring her, that Chastity put on her YouTube page on August 10th, obviously taking advantage of what was happening with Blake, right? But Chastity wasn't involved in this. She simply was a journalist that had an interview and a bad experience with Blake, and she shared that bad experience at a time when Blake was already getting backlash. So, yeah, Chastity didn't do anything, and they didn't tell Chastity to do anything. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.